Please, my Lord, I appear on behalf of the public protector in this matter.
Please, the court, I appear for the DA intervening in all matters.
May it please the court, my Lord, I appear for Bennett Juniors in the Ms. Kofa on behalf of the President of the ruling party, the Congress Party.
As this is the court, my lords, I appear for the second and third intervening party, the United Democratic Movement and Co., together with my learned colleagues, Ms. Tole and Kofa.
Lord, I appear with my learned friend, Mr. Curry, for the royal indication number 8483.
Thank you. Right. We just have a problem here with the aircon, but we'll try and continue because it's hot in here. Hopefully we'll be able to hear each other. We also want to make sure that there is order in what we're going to be doing today. And the first issue that has to be determined is who is in the matter. I say that because there is the main application by the applicant, that is the President of the Republic of South Africa, where the respondents are the Office of the Public Protector and the Public Protector. And then we have a number of intervening applications, parties who want to intervene in that application. So, to make sure that things happen in an orderly fashion, the first issue we would want to deal with this morning is the issue of the intervention applications.
My lords, if I may, just before we start with that issue, the lordships will remember that there was an issue in chambers about the intervention application of the economic freedom fighters, UDM and Congress of the People in the Van Rooyen application. I beg you to hand up. That application was only served overnight for the reasons that it was received late. I beg you to hand up the copies. And it has now been supplied to Mr. Chico.
Thank you very much, Advocate Mpofu.
My Lord, might I also indicate from the DA's side that the intervention application and Minister Van Rooyen's application was circulated in unsigned form. We have the final signed form, which we beg leave to hand up to the court.
Yes, please go ahead. Right. The first submissions we're going to be hearing are the parties wishing to intervene in the President's application. I think the DA has to argue first as an intervening party.
As the court pleases. My Lord, as far as the DA's position is concerned, it is one of the complainants that gave rise to the investigation into state capture by the Public Protector, as a result of which is the subject of the applications, was issued, well, was signed and finalized in terms of Section 8.3 of the Public Protector Act, the complainant has a right to their findings as soon as possible after they have been finalized. And insofar as the relief being sought impacts on the DA's statutory right to the final report, our submission is that that in itself gives the DA the locus standi to approach the court for relief, particularly where interdictory relief being sought by inter alia Minister van Rooyen has an effect of interfering with the doctrine of separation of powers. And that is an issue in which the DA further has a very clear right. Our submission is that that, in short, is the answer to all issues where the DA seeks to intervene. And that is, in addition to that, it is a political party in the same position as many of the others who represent constituents with a public interest in the proceedings. And for that reason, our submission is that the DA's role and right to intervene in this matter should be beyond question. And our submission is that only vague opposition to it has been raised, none of which is substantial or substantive, and we will move for the granting of the DA's intervention and ordering that those parties opposing it pay costs, as the court pleases.
Thank you very much, Advocate Labuskaghni. Now for the EFF.
The President, the court note, my name is Julian Whitehall is going to move for the intervention of the EU.
Thank you.
As the court please, the EFF's position requires that we look at this firstly from a historical perspective. What originally happened, which got the EFF to intervene, was an application brought by Mr. van Rooyen under case number 807-07/16. That application, your Lordship will recall, was brought before Justice Fourie on the 14th of October 2016. The EFF applied to intervene in that application, but it also applied for a counter application, a separate substantive application for a declaration for an order that the report should be released. Subsequent to that intervention application, we know that the matter then came before Justice Fourie, and Justice Fourie then granted an order on the 14th of October, essentially saying that the applications, in other words, the Van Rooyen application and the President's application, should be held together contemporaneously, and they were set down for a hearing today. Mr. Van Rooyen, as we know, subsequently withdrew his application. But that withdrawal application had no impact on the EFF's counter application, because as your Lordships know from the decisions that we've cited in our heads of argument, particularly in paragraph 4.2 at page 3 of our heads of argument, the authority of the AD in the case of Luster Products, this as metric style, says that the proceedings, in other words, the main and the counter application, consist of separate applications having a certain overlap and being argued at a combined hearing, but separate and independent applications nonetheless. So the effect of the withdrawal of the Van Rooyen application was essentially to then leave the EFF application standing on its own, in other words, the application to compel the public protector to release that report. So on that first basis, that the counter application brought by the EFF on the 14th of October stands and has not been opposed by the public protector, and presumably it is opposed by the President. So we have a separate application that we have an interest in having held, regardless of what your Lordships believe or think about the consolidation or about the intervention as such. The EFF has an independent application for a release of the report. So that's the first basis for the EFF's intervention. The second basis is it's not clear to us when one reads the President's opposition to us, it's not clear to us whether or not it is contended that the EFF's left standing in the sort of classical locus standi sense, in other words, the capacity to intervene, in the capacity to sit in, or whether they argue that the EFF has no interest in the application, and those two are separate concepts, and they seem to be, in a sense, argued together by the President. And insofar as the first question is concerned, does the EFF have sufficient locus standi to join proceedings and to seek a separate order that directs the disclosure of them? We've cited the judgment of the full bench of the Free State in paragraph 7 of our heads of argument, and that draft a judgment in Bioenergy Africa versus Freedom Front Plus, 2012, volume 2, SA page 88, full bench division, Free State. And there it makes it clear that this is the passage. It seems evident that the Constitutional Court has given an extended interpretation to Section 38 to incorporate violations of and threats of all rights, obligations, values, and principles contained in the Constitution committed by public bodies or public officials. And then it goes on, and then it makes it clear that the standing of political parties is now beyond any contestation, where the issue sought to be determined concerns the enforcement of rights, obligations, values, and principles. You also note that the EFF's main argument seeks to enforce a constitutional obligation sourced from Section 182, sub 5 of the Constitution, which makes it clear that once a report of the public protector has been finalized, there is a duty to publish it. The EFF also seeks to enforce Section 8, capital A of the Public Protector Act, which also makes it clear that if the report of the public protector is finalized, there is a duty to publish it. So the EFF has standing in the sense of political parties seeking to enforce the performance of the constitutional obligation. And then the third question, which again seems to be convenient by the President's opposition, is the question of interest. Political parties have an interest in the affairs of their country. This is a case not like any other case. This is a case that involves the highest office in the land. The EFF is the third largest political party represented in Parliament. It has a direct interest in what happens with the affairs of the country in relation to the conduct of the president. It has a specific interest in ensuring that the conduct of the president is consistent with the Constitution. This case also implicates another power, which is a Chapter 9 Constitution, which is what should happen to reports of the public protector that have been found to be final, that have been declared by the public protector to be final. Should they be withheld from the public, or should they be disclosed to the public? And then the third element that is raised by the case is the rights of the public to know what the public protector has discovered. And in relation to those three capacities, the role of the president, the capacity of the public protector, and the interest of the public to know about the findings of the public protector, the EFF clearly has an interest to come to court and to make a second order declaring that there must be a disclosure of that report. So in reality, there is no substantial opposition to what the EFF is asking. The complaint that is made is a technical complaint, which essentially goes along these lines. Well, you did not formally ask for consolidation. You did not formally ask for an intervention in the president's application. But that level of formalism, quite apart from the fact that it's inappropriate for the head of state to be running a case as importantly as on formalistic grounds, the problem is that that formalism overlooks what happened before Justice Correa on the 14th. Because the president was, of course, here represented by senior counsel and by a senior attorney. It was agreed in that discussion that all of these cases would be held contemporaneously with the Van Rooyen application. If there had been any issue, any question mark about the propriety of that course of conduct, no doubt the representatives of the president would have raised the concern and said, no, we do not agree that the EFF is entitled to participate in this proceedings. So the mere fact that there was an agreement, and I do recall because I was in court with Justice Correa asking towards the end of the finalization of the matter about the heading in relation to the matter. Every advocate who was in court on the day stood up and said, no, Judge, everybody understands along common lines what will happen on the first. So we are, I must admit, taken a little bit by surprise that the president, at the last minute, now seeks effectively to resign from an undertaking made that all of these cases will be held jointly together. They may argue that technically there will be no consolidation, but it's quite irrelevant because the spirit of the agreement of the 14th of October was that everything was going to be held together. That, of course, makes sense for another reason, Justices. In a consolidation application, the only question of law is convenience, and of course making sure that no one is prejudiced. The president does not want to any prejudice that they will suffer if all of these cases are held together. They don't say that we are going to suffer prejudice because you have not given us a chance to respond, or we're going to suffer prejudice because you have not given us a chance to file heads of argument, etc. They simply say we want you to comply in the most formalistic level with a consolidation application. We would argue that in a case as important as this, the court should not be detained by that kind of formalism in relation to the argument. And the question really is, what prejudice is the president suffering? We submit that there is no prejudice that the president is suffering. So in summary, these are the three submissions that the EFF makes. One is that its counter-application for the release of the report stands. It is not opposed by the public protector. It is presumably opposed by the president, and it is presumably opposed by Mr. Van Rooyen. And that counter-application does not depend on any question of intervention. It is a self-standing, separate application according to the authority of the AD. Second point, the EFF has got standing under Section 38D and E in its own name and on behalf of its own members, and also in the public interest, to sue and to ask for the relief that it is seeking for. Number three, the EFF has a direct and a material interest in relation to the affairs of the country. They want to know what the president is getting up to. They want to know what the public protector is getting up to. And as a political party, they have a requisite interest. And we've cited the relevant authorities. So we would, like the DA, move for an application admitting the EFF as a party, not simply in the Van Rooyen application, but also in the president's application. As the Lordship please.
My Lords, Justices, if I may, with the greatest respect, approach the same question from a slightly different angle. Before I do that, I'd like to concur with my learned colleague, Mr. Ngaitobi, that the question of the so-called consolidation, or what we call the effective consolidation of the matters, has happened on the 14th of October, is intertwined with this question. There can be no doubt, if anybody looks at the order of His Lordship Mr. Justice Fourie on the 14th, that the matters were, as we put it in the papers, effectively consolidated. And what is more, that effective consolidation was done by consent. In other words, with the agreement of the parties. It was indeed raised by the court, as the court is entitled to do, for practical purposes, as to whether it would make any sense to hear these cases in a piecemeal fashion. Now, be that as it may, the question then arises, there are three intervention applications where we, my clients, have placed an interest. And I'll call them, the first one is Van Rooyen 1, which was the original Van Rooyen application of the 14th of October. And then is the intervention in the application of President Zuma, and then the current intervention application in Van Rooyen 2, which is the re-emergence of Minister Van Rooyen yesterday as a party. Now, the way to look at this, so that we don't do in a piecemeal fashion, my lords, is to go to the tried and tested test of direct and substantial interest. I will leave the question of locus standi, which is obviously related. Mr. Ngaitobi addressed it adequately. What then is the interest of the UDM and COPE in this matter? Well, that question can only be answered, my lords, by first looking at why are we here? What is this about? Because to have interest in the matter, what is the matter? The matter is simply whether or not the report of the public protector should be released to the public and to the National Assembly according to the statute. Because those are the two methods by which the public, which is being protected, receives the information. It receives it directly, firstly through media releases that are done by the public protector, but in a political sense or formalistic sense, it receives it through it being delivered to the National Assembly and all sorts of other steps taken. That is why, for example, when the order was given for safekeeping, the report was referred to the Speaker of the National Assembly. Now, the parties that I represent are players in that National Assembly. It is they ultimately who are going to be seized with this matter once it is received by the National Assembly. It is they who will take the necessary steps which must be taken in terms of the Constitution to take the matter to its logical conclusion. And I just want to address that. Let's put aside for a minute what the political parties say. Let's listen to what the President himself says about this matter. At page 17 of the application for the paginated papers in their intervention bundle. It's marked on mine is marked the main application. Page 17 would therefore be paragraph 39 to 43 of the President's application. Thank you. The President says, I am advised that I need to show irreparable harm in order to justify the relief sought. The irreparable harm I will suffer will impact on my person as head of state as well as the office I hold. Now, we agree with the President on that score. Now, if that is so, then what he's alluding to, any threat, real or perceived, to the office he holds, simply means that he appreciates that the implications of this matter might lead to the invocations of the impeachment proceedings or the motion of no confidence in terms of sections 93 and 102 of the Constitution. '89, 1 and 2, and 102, 2. I beg your pardon, my lord. Now, those threats, perceived threats by the President, for them to be realized, which are real, we agree with him, can only be invoked by, among others, the parties that we represent. Because Section 89 says, the National Assembly, by a resolution adopted with a supporting vote of at least 2/3 of its members, may remove the President from office only on the grounds of A, serious violation of the Constitution, serious misconduct, and inability to perform the functions of the office. With the greatest respect, my lord, this is a case that implicates all those 3 grounds of impeachment. If true, and we don't express an opinion at this stage, because this is the interlocutory stage, but if true, the allegations that are being made against the President in this matter would implicate all those 3. It would, without any doubt, and we will deal with this when we deal with the merits, constitute a serious violation of the Constitution if indeed the President abdicated his presidential powers to appoint cabinet ministers to some private interests. I cannot imagine a bigger serious violation of the Constitution than that. If it would also fall under Section 89B, which would be serious misconduct. But more importantly, it would fall under Section 89(1)(c), which is the inability to perform the functions of his office. In other words, the functions of his office, which are defined in the Constitution, would have been abdicated and relegated to somebody else. Section 102 is along the similar lines, to save time. The only difference between Section 102.2 and Section 89 is that in terms of Section 102.2, it is the motion of no confidence provision, and that is done merely by the majority of the members of parliament. Section 89 is done by 2/3, but that's a difference that is not important for the purposes of this discussion. So nobody else is going to realize the threat that the president has correctly identified about the matters that are implicated in this case, other than the political parties represented in parliament. Or to put it differently, and to piggyback on Mr. Nkaitobi's broader definition, other than the public. Remember, this is the public protector. But the public will only exercise its punitive or sanction abilities around this matter through the agency of political parties. That is how our democracy is structured. Because the public doesn't, on a daily basis, express itself. It does that through the agency of political parties. And so the political parties are playing exactly that role, that constitutional role of ensuring that there is accountability and all the other issues raised in the Constitution. My Lord, if I may just jump very quickly to page 159 in the same bundle. That would be paragraphs 52 to 55 of our replying affidavits. If your lordships are there. Thank you. The connection with my submissions is made in those two paragraphs, if I may just read them. It says this application is a matter of public importance. If the allegations made against the president are correct, submissions that I've made, they will prove that the president has acted in contravention of the Constitution. This will in turn mean that he has abdicated his executive responsibilities to private interests. 54, the intervening parties have always maintained that the current president is not fit for office. Any proof that he has abdicated his presidential functions to a private party will show that he is not fit for office. It is only the intervening parties who can trigger the constitutional process which would follow from that fact. In other words, this goes in line with the president's own admission of what this application is all about, but also just a common sense. All you have to do is just to read the heading of the letters of the public protector. What is being investigated here? It is the conduct of the president and his relationship with the Gupta family, more particularly in relation to the appointment of ministers. So all those are subsumed in here. So with the greatest respect, my Lord, the intervention application is, in fact, our jurisprudence, more particularly given the recent cases of the DA versus the president, EFF and the DA, the so-called Nkandla case and so on. Our jurisprudence has now developed to such an extent that the role of political parties as the broader protectors of the public and the Constitution is almost taken for granted. So the political parties that Senator Toby has submitted are acting in their own interest, but also in the interest of their members and voters. And with the greatest respect, the intervening political parties as such in this particular matter represent not less than the voice of not less than 5 million voters, roughly speaking. Now, the next question that is raised, my Lord, is the question of the intervention in the president's application. I will not bore your lordship with references, simply to say this. His Lordship, Mr. Justice Forey, will remember that when we were here on the 14th, the first thing I did was to apologize to my learned colleague for the president, Ms. Platt, because we had effectively dragged her here at the last minute. And that is because in our intervention application, which technically was in the Van Rooyen application, we cited deliberately and advisedly, we cited the president as a party. And that's why Ms. Platt had to be here. That was the only reason. Otherwise, she had no reason to be here on the 14th. Why then did we cite the president? We cited the president because any cursory reading of our application for intervention will show, my lords, that we refer to both parties. Many, many times, I don't have to go to the papers. It says neither the applicant nor the second respondent can do this, neither the first or the second respondent were not given adequate time, and so on and so on. In fact, there's a specific reference in that affidavit which is directed solely to the president, where we say we are going to contest, as we do, the right of the president to be represented by the state attorney in these matters. And that is directed, I'm not making that point now, I'm simply saying that those are allegations which in that founding affidavit are specifically directed at the president. So there could have been no doubt in their minds that the intervention application, while at face value it might have looked like it was merely for the Van Rooyen application, actually was directed at them both through the substance of the affidavit and the mere fact that they were cited and brought here to court.
Mr. Ngugaintobi covered the issue of the court order of the 14th.
Yes.
In case that's where you're moving to.
No, I'm not moving there, my lords. I'm moving to the issue that the effective the intervention application, because remember there's an argument that says, or that will be presented, no doubt, that the president's application stands separately, and it should not have been, or rather, we have no right to intervene in it. All I'm saying is that, my lord, to crown it all, the president, at a stage when he knew that Mr. Van Rooyen had withdrawn, chose to answer to our intervention application. He could not have chosen to answer to our intervention application unless he knew, which he did, that our intervention application also covered the president. That answering affidavit where he says, whatever he says about the DA also applies to us, betrays any latter complaint that there is no intervention application in respect of the president. So that covers now what I call Van Rooyen 1 and the president's intervention. It was all covered in the original application for intervention, which in our respectful submission was effectively consolidated. So what of the Van Rooyen 2, which is the latest application? Well, we oppose that application. Well, firstly, the papers that I've headed up, my lord, the affidavit serves for two purposes. It serves as a founding affidavit, quote unquote, for the application for intervention, but it's also an answering affidavit to the Van Rooyen application. So insofar as it is an application for intervention, firstly, well, we firstly say that we intervene for the purposes of opposing the so-called urgent application of Van Rooyen this time around. And the grounds thereof are set out in the papers that I've handed up. That application, with the greatest respect, cannot be catapulted and bulldozed back into this application.
Advocate Mbofu, I thought we were just dealing with the interventions to the president's application. We'll come back to the Van Rooyen one. Yeah.
Well, in that case, my lord, then I'll confine myself to the arguments that I have made in relation to the president's application, yes, which, with the greatest respect, must be read together with the submissions that I've made on consolidation.
Yes.
The last word, my lord, and again I won't waste the court's time by reading, is that at the appropriate time, we will refer to the recent case of the Economic Freedom Fighters versus the Speaker of National Assembly and others, which is 2016-5 BCLR 618CC, or the so-called Nkandla case. And in that case, again, without reading specifically, the learned Chief Justice makes it abundantly clear that the role of the President, he calls the President a so-called constitutional being, and that the role of the President permeates across the democratic process in relation in particular to what we are here for, which is the value, the constitutional value of accountability, which is in Section 1 of the Constitution. As
Thank you, Advocate Mpofu. The next to argue is the intervening party, Ms. Mentor. If you are covered by the submissions made, please say so, because we don't want you to traverse ground that has been laid before us.
My Lord, I will bear that in mind, and to the extent that my submissions have been made by other parties, I'll be very brief.
Yes.
My Lord, just by way of a very brief factual background, the factual basis or the factual background to Ms. Mentor's application to intervene is that she is a member of the ANC and she was formerly a member of Parliament. And in March of this year, she made certain disclosures, certain public disclosures, which served partly as the catalyst for the Democratic Alliance requesting the public protector to investigate the issue which is at the heart of this matter. And she then subsequently also was called upon by the public protector and willingly cooperated with the public protector's investigation. And so, and by way of legal background, my Lord, Ms. Mentor originally sought leave to intervene on two bases. Firstly, because in correspondence between the President and the public protector, and in the President's original founding affidavit, he appeared to assert the right to cross-examine persons who had cooperated and had been interviewed by the public protector in person, either directly or through his legal representative. On that basis, so that was the first basis on which Ms. Mentor sought leave to intervene, because her rights would obviously be affected by that. But secondly, also, she asserted the right to intervene on the basis that, as a member of the public, she has a right to the release of the public protector's report. Now, in the President's answering affidavit to Ms. Mentor's application, he has dealt at great length with the first basis for her application to intervene, which was the issue of questioning witnesses who had been interviewed by the public protector. And it's very clear from that answer that he does not now assert the right to do so. He concedes that that is not a right that flows to implicated persons under the Public Protector Act. And so, of course, my Lord, we concede that that then is an answer to the first basis on which we sought leave to intervene. However, it doesn't answer the second basis, which is that as a member of the public, Ms. Mentor has a right to the release of the public protector's report, and it's that right which she serves to protect in these proceedings. Because obviously, if the President's relief is granted, that right will be frustrated, and we submit that on their main group, there isn't even a time rule as there was in the first notice of motion. It's just whenever the President has been afforded all of his rights that he alleges he's entitled to under the Act. And so, theoretically, he could frustrate the release of that report for a significant, if not indefinite period of time. My Lord, the legal basis for that second basis on which Ms. Mentor seeks leave to intervene, and she does so, my Lord, on two bases. Firstly, under Section 38A of the Constitution, in her own interest, as someone who made public disclosures and cooperated with the public protector, because she firmly believes that this is an issue that needs to be properly brought to light, investigated, and resolved to the extent that it can. And so she asserts the right in her own interest under Section 38A of the Constitution, but also in the public interest under Section 38B. And we submit that the legal basis for that right is, with respect, very clear. It flows firstly directly from the Constitution under Section 118 was described as a constitutional gift to our nation in the fight against corruption. Thirdly, that she exercises her mandate in the public interest. To paraphrase the Chief Justice, the name really says it all. It was for the public protector is there to protect the public. And so my lords, it must be that the public, and I would submit any member would have the right to bring an application to compel the release of the public protector's report. If I could just, in conclusion, posit this hypothetical scenario. If we could imagine a situation where the public protector refused to release a report, and my lords, I just want to clarify, I don't want to be understood in any way to be suggesting that the current public protector is or might do that. I don't think that at all. I just say that if you imagine a hypothetical situation of that occurring, where for whatever reason the public protector refuses to release a report, and of course it's unlikely that the government would then take steps, or certainly those persons implicated in such a report, to compel its release. It must be that a member of the public in those circumstances would be entitled to bring an application to compel the public protector to release the report, because otherwise the mandate would be completely and entirely frustrated. And so I submit that on that basis, Ms. Neto clearly has a right to intervene in these proceedings in her own right, but also on behalf of the public.
Thank you, Advocate Lewis. Ms. Platt, for the President.
I would answer to all intervention applications, and where there are nuances and differences attaching to each, I will then make submissions with regards to those ones individually. Yes, sir.
Pick up your voice, it will help. Are you opposing all the intervention applications?
I'm opposing all the intervention applications. I will make one submission with regards to all of them, and where there are nuances and differences in relation to each of them, I will just touch on that.
Perhaps before you start, in order not to break your flow,
Yes, ma'am.
what do you say about the court order of the 14th of October?
The court order of the 14th of October was not a consolidation application. My lord, when I appeared, I stood up and said that I was here for the second respondent, and I was not sure why I was here because I hadn't served with any papers. And that was the submission made on behalf of the applicant, President. We were told we are a second respondent. Then they said intervening parties can then file papers on the Monday. We agreed to that. And we had expected a proper joinder application with regards to the EFF and UDM and COP. Just like the DA did. The DA intervened in both case numbers. It intervened in our case as well as intervened in the Van Rooyen, as my learned colleague Mr. Mpofu says, Van Rooyen 1. So the DA intervened in both. Ms. Mentor intervened in this one. Yes, my lord.
Did you, and every time I say you, please, I'm referring to your client, the President.
Yes, my lord.
Did you not agree to the applications being heard together?
I agree that the applications should be heard together. Yes, my lord.
So it is the formal consolidation you're opposing.
Well, there was no formal consolidation.
Well, they seek it now.
They seek, my lord, there's no formal papers before you. They raise in a replying affidavit a joinder. But my lord, we're not going on the consolidation. If my lord feels that there is a consolidation, we're not going there. Our opposition is not directed solely on consolidation and joinder. Our opposition is based on direct and substantial interest. And that's the point we're going on. That's the point we're relying on, not on the Section 38 joinder consolidation, any of those points. If we fail on direct and substantial interest, we will fail on any of the other ones. My lord,
You may continue, Advocate Platt.
yes, my lord, this is an application in where the President has come to enforce procedural rights. That procedural rights attaches to the President and the President only.
those procedural rights do not attach to the public, nor do they attach to the political parties or to any intervening party. And those procedural rights and the processes followed therein has been admitted by the respondent. So the applicant brought an application against the respondents, which is the public protector, to enforce procedural rights. My Lord, and if I could take you to page 83 of the main application, which is the respondent's affidavit.
What page? 83?
Page 83 of the main application bundle, paragraph 6.7.1. It says, the facts, 7.1. It says, the facts concerning the process followed by Advocate Madonsela in preparing the report are essentially as set out in the affidavit of the President at paragraphs 13 to 27 of his founding affidavit, excluding paragraph 21, which amounts to comment on the facts. To the extent that those paragraphs annex and set out the correspondence between Advocate Madonsela and the President, they appear to be accurate and constitute the common cause facts on which the President's application falls to be decided. That is what the Public Protector has said, that the common cause facts on which the President's application is made has been agreed to. They are common cause between the applicant and the respondent, because these are procedural rights that can only attach to the respondent, to the applicant. It's the applicant that is being an implicated person. It is the applicant that's being asked to answer questions. It is the applicant that was given the right to pose questions to witnesses by the Public Protector, in which she says she will determine the process in terms of the Act as to how those questions can be posed and to who. So the Public Protector has admitted all those facts. Those facts cannot be refuted by any of the intervening parties, because they...
I just want to understand.
Yes, ma'am.
Do you submit that the procedural rights, which you say attach to the President alone,
yes,
should be looked at in isolation, excluding the rights of any other person?
Because this is what the application is based on.
But is that your submission?
Yes, and I'll explain why I say that later. So the only two parties that are aware of the procedural requirements are the applicant and the respondents. And both have made common cause amongst each other on the facts. So there's no party that can refute those facts. They attempt to do so, but they cannot refute it because they say they don't know the process or they don't know the questions. So on that basis, we say that because there are procedural requirements that needed to be followed, which has been admitted by the respondents, that relief attaches to the President only. Now, with direct and substantial interest, can I just quote from, sorry. I'm sorry, this just did some funny thing now. Sorry, my Lord, we're just trying to... Okay. It's Gordon versus Department of Health, 2009, 1, All South Africa, 39, SCA at paragraph 9. And the Supreme Court of Appeal stated the following: the issue in our matter, as it is in any non-joinder dispute, is whether the party sought to be joined has a direct and substantial interest in the matter. The test is whether a party that is alleged to be a necessary party has a legal interest in the subject matter which may be affected prejudicially by the judgment of the court in the proceedings concerned. In the Amalgamated Engineering Union case Supra, it was found that the question of joinder should not depend on the nature of the subject matter, but on the manner in which and the extent to which the court's order may affect the interests of third parties. The court formulated the approach as first to consider whether the third party would have locus standi to claim relief concerning the same subject matter, and then to examine whether a situation could arise in which, because the third party had not been joined, any order the court might make would not be res judicata against him, entitling him to approach the courts again concerning the same subject matter and possibly obtain an order irreconcilable with the order made in the first instance. And we say that the intervening parties do not have a right to intervene on that basis, because in order to state that procedural requirements as attaching to the president was not followed does not affect their right to know what is in the report. Because if that order was given, it is not irreconcilable with any other order that they could attain. Because once those procedural requirements have been met and the report released, they have every right to look at that report and deal with it on that basis. We're saying that procedural requirements as attaching to the president cannot be a direct and substantial interest, because they cannot say that their interest to know has been affected by the president obtaining an order that he has the right to answer questions. They cannot say that that is a direct and substantial interest. They cannot say that he has a right to ask questions that it will affect their rights to know. Because ultimately, once those procedural requirements have been fulfilled and a report issued, they can then challenge that report as to whether there is any other basis for why they have a difficulty with it. If that is the case, it doesn't affect the order that the president seeks. And that order is merely, give me an opportunity to exercise my rights, as you say I have. As you've said to me, I look forward to your questions, Mr. President, in relation to the witnesses, and I will determine how that procedure will follow. The public protector has said that, and then promptly thereafter finalizes a report. We are saying procedural requirements were not followed. The public protector has agreed with that, and it's on that basis that we say any order here will not have a direct and substantial interest on any of the intervening parties. My Lord, and then we will not go to Section 38. I just want to check that I've covered everything. So the direct and substantial interest will go through to all parties. The submissions made by UDM and COPE with regards to impeachment, that happens in a different format. No order here will affect impeachment proceedings. Those happen in Parliament and not in front of this court. So what is in the report and its outcomes will not affect the political parties if the president is given a right to fulfill its procedural requirements that the public protector has agreed he has. With regard to Ms. Mentor's application with reference to cross-examination, we do concede that it's not a cross-examination. However, we are entitled to pose questions as determined by the public protector in terms of the Act. And we're saying on that basis, we are allowed to ask questions. And it's the public protector that will determine how those questions will be posed and in what format and whether she will be posing those questions. Because the letter reads, and if I can just take you to that letter, it's Annexure K, my Lord, page 72 to 76. It's paragraph 11, page 75, my Lord. This is on the 11th of October, 2016. And she says, I look forward to receiving the questions you wish to pose to witnesses who have appeared before me. I shall make a determination on such questions in accordance with the Public Protector Act, creating a legitimate expectation by the President that he would be allowed to ask those questions. That has not been denied. Yes. The Public Protector gave the legitimate expectation to the President, that he would be able to ask questions and she would determine how that would happen. And that is correct, because that's what Section 7(9) of the Public Protector Act says. So we say on that basis, that Ms. Mentor does not have a direct and substantial interest in the matter. And as a witness, we say that in the Hudham's decision of the Supreme Court of Appeal, in the National Director of Public Prosecutions versus Zuma, 2009, 2 SA 277 SCA, at paragraph 85, it says, I'll read from 84, just to give context. In this matter, Mr. President Mbeki, as he then was, sought to intervene in an application in their appeal. And the court says, nevertheless, to be able to intervene in proceedings, a party must have a direct and substantial interest in the outcome of the litigation, whether in the court of first instance or on appeal. The basic problem with the application is that the applicants have no interest in the order, but only in the reasoning. They are in the position of a witness whose evidence has been rejected or on whose demeanor an unfavorable finding has been expressed. Such a person has no ready remedy, especially not by means of intervention. And that is Mrs. Mentor's entire case, that she gave evidence, she is a witness, and therefore she needs to intervene. And we're saying, according to the SCA, you do not have a right and a ready remedy to intervene in an application of this nature. My Lord, and she also states, Ms. Mentor, in paragraph 49, page 17 of her intervention application. It's paragraph 14. Page 17, paragraph 49 of Ms. Mentor's application. She says, indeed, had I known that as a consequence of my disclosures, I would have been at risk of being cross-examined directly by the President or his or her legal representatives, I would have been far more circumspect about making the disclosures in the first place. Thus, if the President's interpretation of Section 792 were to be adopted, it would hamper the Public Protector's ability to combat corruption. And we say this can never be the case, because as the Constitutional Court has said, the Public Protector's findings are binding. So therefore, the proper procedural requirements need to be followed in order for that binding finding to be made. And for a witness to say that they would have been far more circumspect in making their disclosures is very worrying, my Lord. My Lord, so that is the basis of which we oppose the applications, that they do not have a direct and substantial interest on purely procedural requirements on which all of the parties have no direct facts to rebut what the Public Protector has said. As it pleases.
We're going to adjourn for 15 minutes, and then we'll hear the replies. We'll take it from there. Court adjourns.
Sorry.
Can you check your audio? Because we're moving away from the fans.
That's the problem. When they walk in, somebody Sorry, man. Can I just grab this real big technical?
Hi. You don't say hello.
I thought you were never even going to smile at me again. After that WhatsApp I sent you about Chiba and...
So, I can, in the meantime, do you want me to
Yeah.
create a separate...
Yeah, it's not just the Guptas. Also, I say it's not just the Guptas who steal. Yeah. Some people even steal my junior.
And record them as
Yeah, junior capture.
So the Guptarized your
The Guptarization of my junior. But you said to send notes. Where are the notes?
the notes. Okay.
But why are we having armed people all around the place?
I'm a Barrett or Nohal. Hey, TRT. Some of us don't take kindly to the TRT.
Okay, this is the first
Oh, yeah.
here.
Okay, that's the merits. No, we'll deal with this.
And then, okay, this was the case that Rodney wanted.
Oh, Trill, I think he dealt with the agent.
Have I got that?
I emailed it to you at 2 this morning.
You don't have that?
This is the, but I've given you another copy. No, I've given you another copy.
Oh, you did?
Yeah, I gave you another copy.
Oh, I just said.
I gave it to you earlier. This was mine.
Oh, was that from you?
No. This was mine.
Okay, no, I'm sure it's here. Yeah, this take the merits. Don't you something? We still have to do the... I'm saying we'll have time to look at this. Because we still have to do
Yeah, there we go.
And that's in the file.
And it's in the report, yes. And it cited, it cites this case. So put the facts down fully to say here are the facts in this case. This is what the PRC that said we can't deal with this.
We have copies.
very much in high spirits, still making their voices heard. The majority of the protesters behind me, if I can just step out of shot, as you will see, are draped in EFF party regalia, and they are carrying various placards basically calling on for the courts to defend the democratic state and to defend what they say are hard-won democratic rights, and speaking to the issues which are now being debated and being argued by the various legal councils here at the Pretoria High Court. It's been a very peaceful demonstration here outside, but I must say that the protesters themselves have created quite a spectacle, and ever since the court proceedings started, they have been in high spirits and they have not let up since. Many of them have been looking very curiously at the various media vans that are here beaming the satellite feeds of what is happening in court all across the world, and as they look into the screens, they nod knowingly. Some who can hear what is being said react in their own ways, but I spoke to them earlier, especially the EFF supporters, who said that they basically feel that the wheels of justice are turning and they have every confidence that the court will do the right thing and in time will possibly rule in their favor. Of course, we are watching proceedings from inside very, very closely to see how this will possibly play out.
I only see EFF supporters in the background there. Is there other parties also present?
I beg your pardon, Elvis, could you just repeat the question? It's really, really loud out.
Yes, I can hear it's very loud out there. I only see EFF supporters in the background there. Is there other parties also present supporting the bid for the president or not?
No, certainly the EFF supporters are out in their numbers, but the other political parties that are represented would include the Democratic Alliance and the Congress of the People, who are also basically here in court as part of proceedings. There are a few scatterings of their supporters, but mostly it is party officials that are now seated in the benches inside the court itself. So certainly all the interested parties are out and they have been represented here.
Tumawole, thank you so much for that report. In 15 minutes, the court will resume and we'll go back there live. Let's now take
It's this one here. Are you okay with it? All right, sharp.
There in chambers as they are preparing for the second half of this proceedings happening in the Pretoria High Court, the North Gauteng High Court, that is happening today. What will come out of these proceedings today? We want to find out, and we'll know then probably by the end of the day what is going to happen, whether the report will be released or whether that report will stay captured. And we await for that outcome as they prepare for the second half of the proceedings in the North Gauteng High Court there in Pretoria. Earlier you've heard some of the lawyers coming through and giving their side of the story in terms of why the report should not be released, indicating that the President did not have enough time to give his point of view, and of course not having a chance to interview the witnesses to the report, and that is why they're in court today, to stop the report from being published and being released. As we still wait for the second part of the proceedings at the North Gauteng High Court, some of the hacks, as you can see there's some of the media. They are waiting patiently, and some of the party leaders also in the gallery there from the Democratic Alliance. I see there James Self, and also from the EFF, some of the members there, and as they're filing into the court to continue the arguments today, and we'll know probably by the end of this day when, if the report will be released or not. We'll take a short break and we'll be back right after that while we wait for the court to start.
Right. Advocate Platt? Yes.
So our argument should be seen in light of
Yes.
the Rule 30 application. And in our affidavit that we filed to that application, the counterclaim of EFF, UDM and COPE, we specifically say at page 40 in the intervening party's application to intervene bundle 1, if regard is had to the main application, it is patently clear that the President is not a party to these proceedings. Therefore, I'm advised that it's not permissible for me to participate in these proceedings until such time as I am formally joined as a party. Thank you, Madam.
Thank you, Advocate Platt.
May I mention something?
Yes.
We are not strictly concerned with this application, as your Lordship will appreciate.
Yes.
But there is something to be mentioned regarding case number 80707, which was the previous application. Yes. I would avoid that, but nevertheless. And that is this. In the argument on behalf of the economic freedom fighters, they state that they have a self-standing counter-application. Well, of course, we don't dispute that a counter-application is a self-standing application. But before you can bring a counter-application, you must be a party. And they were never admitted as a party to 80707. So when the two parties agreed to settle the matter, or it was withdrawn, the so-called counter-application fell away. So the logic is incorrect. That's the only point we want to make in that regard. Thank you.
Thank you, Advocate Deutsch. Thank you very much. Yeah. Sorry, just before you argue, Advocate.
Mr. Deutsch, is this irrespective of whether or not you are part of the so-called agreement of the 14th, which was the basis of a court order? Does that have any impact on what your submissions?
Lord, the agreement was only that the matters would be heard contemporaneously. Yes. Subsequently, Mr. van Rooyen withdrew his application by agreement with the Public Protector on a particular basis. Therefore, that application fell away. And therefore, the application to intervene fell away as well. And as no intervention had been granted, the counter-application never arose.
I raised the question because you would have seen that most of these applicants for intervention say that there was effectively an agreement for them to join.
I don't know what that means, my Lord, with great respect. There is either a consolidation or there isn't. You can hear matters contemporaneously as a matter of convenience. With respect was correct. We don't take issue with that. But there was no consolidation. That's clear. And in fact, I believe the Public Protector says that as well.
Just before you sit down, I'm sorry to interrupt.
Yes.
I just want to understand your submission. Is the position perhaps not just that if the application has been withdrawn and there was no consolidation, there was no intervention granted, that the so-called counter-application then remains as a substantive application on its own legs?
No.
Why
because not in that case number, under that case number, because that case number ceased to exist. When the application was preceded by an application to intervene. When that fell away, then there's no more counter-application. You can't bring a counter-application in a matter in which you're not a party.
Thank you, Advocate Detroit. I think that's the issue we have to resolve at the end of the day, isn't it? Thank you. Just before I hear the replies, the respondent in this matter has stated that she will abide the decisions regarding, she's not opposing any of the intervention applications. Am I correct?
That's correct, my Lord. The Public Protector abides all of the interlocutory applications and the application for postponement and amendment.
Yes. So you've got no submissions to make?
No submissions at all, my Lord.
Thank you very much. Now, the reply by the Democratic Alliance. Thank you.
My Lords, I'd like to make just 3 short submissions in reply. The first is that we've heard no counter to the basis on which in which the DA asserts its direct and substantial interest, namely Section 8.3 of the Public Protector Act, and the interests that it has as a political party under Section 38, as confirmed by the SCA judgment in the Spy Tapes matter. The interest of political parties in matters relating to the President is a matter that should not be subject to debate before this court. It clearly establishes the interests of political parties in a matter such as this. The second point we wish to make is that there is a fundamental error in the argument advanced by the President, in that what the President has lost sight of is that there is now a final report of the Public Protector. There are no procedural rights of the President to be preserved. The only question is whether the report should be released or not. And if released, the President is free to challenge it on review in due course. But that is not an issue which is urgent, and that is not an issue that should detain this court as an urgent court. What the direct and substantial interest of the DA, what relates to it, is that it is the relief that the President sought that determines whether the DA has an interest in the common law sense of a direct and substantial interest. That is the second error we submit the President makes in the submissions to this court. That is that the relief sought in the application of the President includes interdictory relief precluding the release of the Public Protector report. That is an issue that affects the interests of the DA directly, and it has the interest to be heard on those issues for the reasons that we have advanced. The direct and substantial interest does not flow from the parochial facts between the President and the Public Protector. It arises from the relief sought and the effect of an order on the interests of the DA. There is no counter to that, and the interests of the DA are determined in that regard on the relief as originally formulated. And that relief includes an interdict pertaining to the release of the report, and we submit that that establishes the direct and substantial interest of the DA. And for that reason, we would move for an order granting the intervention with costs, as the court pleases.
Thank you, my Lord. I have 3 points to make. The first is to respond to the technical point taken about whether or not the intervention application stands as a counter-application. We've already cited the relevant judgment in our original submissions. It's quite clear, Justice Faure is right, that the counter-application is a separate, self-standing application that must be adjudicated on its merits. The withdrawal of the application by Mr. Van Rooyen has no impact on the EFF's entitlement to pursue its counter-application. And insofar as the standing of the EFF is concerned, the EFF raises 2 grounds for the standing. The one is Section 38D and E. Our learned friends for the President have not responded to that at all. In fact, they conceded to court that they have no argument to make in relation to the standing based on Section 38 of the Constitution. Well, if that is so, well, then cut it quite short. That really is the end of the question, because if the EFF is entitled as a matter of law to institute its own application, and it decided for convenience to institute it in the context of Mr. Van Rooyen's application, who was trying to stop the publication of the Public Protector report. So the fact that he now withdraws cannot impact on what the EFF wants to do. It's his election. Whether he withdraws and he opposes, that is up to him. The second point to be made about this is that there are, in fact, 2 judgments. Well, I've cited the first AD judgment. There's another one that my learned friend has just given it to me, and I'm indebted to him. It's a judgment of Mogale City versus Fidelity Security Services. It's reported in 2015, Volume 5, SA 590 SCA. And it implicates the question of what happens when a party institutes proceedings, then subsequently withdraws, but there is a counter-application. What it ultimately resolves is that it's a discretionary question. But here is a passage that I think is vital in relation to how the court should exercise its discretion. It's in paragraph 7 of that judgment. And then it says, even if an application had been brought in terms of this rule, the court would have a discretion in terms of sub-rule 3 whether or not to set aside the counter-application. It is plain that Mayor J would have had exercised his discretion against the municipality, not least because the objection was not initially raised but was made at a late stage. And then they cite Shriner J in the matter of Trans-African Insurance versus Malulek, who says, technical objections to less than perfect procedural steps should not be permitted in the absence of prejudice to intervene with the expeditious and, if possible, inexpensive decision of the cases on their real merits. This is a vital passage because it teaches us, of course, that we should never put form above substance. What is crucial is to always focus on the real underlying substance of the dispute. That takes me to my last point. The President tells the court that this case is really about his procedural rights. But this we can dispense with simply by reference to the notice of motion itself that they filed. In the first notice of motion, they sought an interdict, a blanket interdict, stopping the publication of the report in its entirety. That has nothing to do with process. It has everything to do with everybody's rights of access to the publication of the report of the public protector. They've now amended their relief, and in the amended relief, they don't abandon the attempt to seek a blanket ban on the public protector's publication of the report, and they insert certain procedural demands. But those procedural demands are not possible, as my learned friend for the DA says. They are not possible at this stage of the proceedings because, of course, the public protector has told us in many, many affidavits and letters that I have finalized my investigation. If you have an issue, you know what to do. You must follow PAJA. So the reality is that this is not a case purely about the President's procedural demand. This is a case that seeks to put a blanket ban on the publication of the public protector report. It's not just the President who is interested in that question. It is everybody in this country who is interested in knowing what the findings were. Mr. Mpofu emphasizes the point earlier that this case implicates Section 91 of the Constitution. Is it true or is it not true that the President got third parties to advise him or influence his decision-making when appointing ministers or assigning positions in the cabinet? That is what is at stake in this case, not procedural niceties that the President wishes to put up at every stage of the proceedings. This point is not just made by me, but it has also been made by the Supreme Court of Appeal in another case involving the public protector. It was in the SABC case where the public protector issued a report. This is what the judges say in paragraph 51. This is what the yes, indeed, my lord. It's South African Broadcasting Corporation versus Democratic Alliance and others. It is in 2016, volume 2, SA 522, and it's a judgment of the SA. It was delivered by the Deputy President of that court, Justice Nafsa. This is what he says in paragraph 51. The Minister and Chairperson of the SABC Board are senior public office bearers whose function it is to inspire confidence that all is well in public life. In those circumstances, we think it is unfortunate that they should have chosen to respond to the evidence as they did. Unlike the DA, they were present and intimately involved in what had transpired. In those circumstances, they owed not just the court, but their fellow citizens an explanation. In our view, the overriding public interest obliged them to make full and frank disclosure, rather than shield themselves from scrutiny by resorting to technical points in opposition. This case could not have been designed for a better case than we have today. We have the head of state and we have a minister of local government, both of them hiding behind technical objections to the sole question whether or not the public is entitled to know what the findings are that the public protector has made. I have no further submissions to make.
Thank you, Advocate Ngugaitobi. Just before you sit down, Advocate Ngugaitobi, what is your response to the Rule 30 submissions that Advocate Platt made?
Mr. Mpofu assured me that he would deal with that Rule 30. But it is a groundless Rule 30 because it does not address the counter-application of the EFF, which is predicated on Section 38 of the Constitution. So regardless of the procedural objection that they take, the court still has a discretion, notwithstanding that Rule 30. And in the judgment I cited in Mogale City, that exactly was the point. Rule 30 was debated. The court says even if you are raising a Rule 30, we ultimately exercise a discretion whether or not to overlook the procedural objection so that we can be concerned with the underlying merits of the dispute. This is what we are dealing with here. So we would urge the court to exercise its discretion and dismiss the Rule 30 because we have standing and we clearly have an interest in the content of the public protector report.
Thank you. Advocate Mpofu.
As God pleases, my lords. If I may just start with the point that the Judge President has raised on the Rule 30, so that we get that out of the way. The first answer is the one that has just been provided, that what I call the counter-application point, that the counter-application is capable of standing on its own 4 legs. But the second point is that actually there's no Rule 30 application before you. The only thing you have is a Rule 30 notice, and the rule is very clear that there should be an application. We don't have such an application. But even the notice, as it has been proposed, is groundless. The rule says that a party to a cause in which an irregular step has been taken by another party may apply to court to set it aside. And then an application in terms of sub-rule 1 and so on. And there's no such thing in front of this court. But in any event, it's ill-conceived for a third reason, namely that the basic fundamental premise of Rule 30 is that the party concerned must not have taken any further step. In this case, as we have pointed out, is that the President actually answered to the intervention application, which they technically claim was only aimed at Van Rooyen. But they answered to it. They took a further step. So they cannot come here now and say that that step was not. So this is why the replying affidavit was a replying affidavit to their answering affidavit, which was a separate answering affidavit that they filed directly to the EFF, UDM, and COPE. So that point, with the greatest respect, is beyond even the technical. It simply doesn't hold any water. The second point that I'd like to raise is we accept, I have to say this, we accept that the President has got procedural rights. We accept that those procedural rights will be asserted in due course in a review application. That is not the issue before this court. The issue here, as Mr. Ngqaitobi, my learned colleague, has pointed out, is this. Will the public of South Africa enjoy its access to the contents of the report now, or later, or never, as I'm sure the President would like us to have? The question, that's the only question. The public has a right to this report. The law is very clear on that. The public has got a right to this report as soon as possible, expediently, and all the words that get used. And the only question that is before this court is whether that public's right can be enjoyed now or later. The next point is, my learned colleague seems to assume that we are applying here as amici curiae. We are not. So the submission that the submissions are there and the facts are common cause, there's nothing more to add, doesn't hold any water. We're not applying here as amici curiae. We're applying as respondents, as parties, in the full sense of the word in this application. Then the next point, my lords, is this consolidation point which boggles the mind. And without disrespecting my learned colleague, I simply want to say, if you said in the bar exam to the students, the pupils, if the parties have agreed that the matters must be heard together, as my learned colleague said to your answer, we agreed that the issues must be heard together. So if the parties have agreed that the matters must be heard together, and in the order, the word contemporaneously is used. What do you call that in law? 2 marks. Every student would say, consolidation. What are you talking about? That's all it is. So that's what we meant, as the Deputy Judge President correctly said, when we talk about an effective consolidation. That is what, and with the greatest respect, the word contemporaneously did not come from His Lordship, Mr. Justice Fourie. It came from us, all of us as the parties. We went and had a meeting and decided this is the word we're going to use, and then present it to the court. One of the people in that meeting were the representatives of the president, with the greatest respect. The last point, my lords, is that really what we have here, well, my learned colleague Ms. Platt has interestingly quoted the case of NDPP versus Zuma, which does something strange. In the quest to take out Ms. Mentor, she's letting us in a way, because she said that we must have an interest in the outcome. Now, the interest in the outcome is, as I said in my main address, very clear that the political parties have an interest in the outcome for the reasons that I will not repeat. Before I sit down, my lords, let me just say this, because this might just clarify everything. Sometimes we have to use what we call deductive reasoning. Let's just assume for a minute that the intervention applications were not there. That is what should concentrate the mind. Had that happened, if there were no intervention applications, we would not be here. And the public would not have had a right to assert its right to the report. The public would have been completely barred from knowing whether or not the president of the country abdicated his powers to private interests. And that is simply because the public protector, which is the only party that they would like to have, is not opposing the application, has decided to abide. So the only avenue through which the people of South Africa will know whether or not they have a president who has committed the sins that are foreshadowed in the report is through these intervention applications. That, with the greatest respect, should concentrate the mind to illustrate the very, very point that the big and serious issues that have compelled this court not only to compose a full bench, but also to put the matter over 2 days because of the obvious weight of the matters in this case. That which compelled the court to do that is exactly the same thing that compelled the political parties to intervene. As the court pleases.
Thank you, Advocate Mpofu. Advocate Lewis.
Thank you, my lord. My lord, the submissions regarding the public interest have been largely covered by my learned friend for the EFF, and so I won't repeat them. I do just want to make 2 points, and they are the following. Firstly, my learned friend for the president has relied on an authority. It's the case of the NDPP versus Zuma, and I do have a neutral citation. It's 2009 ZASCA 1. And the relevant paragraph that she referred to was paragraph 85. Now, what that paragraph said is that President Mbeki did not have a direct and substantial interest in that matter because he was seeking to challenge the reasons for the finding and not the order. And of course, my lords, that doesn't apply in this case. The direct and substantial interest, which Ms. Mentor and I believe the other intervening parties, but which Ms. Mentor is seeking to assert, is in the relief that the President seeks, which is to interdict. Even if in the amended notice of motion the word interdict isn't used, the effect is still to interdict the release of the Public Protector's report. And so there is a very compelling public interest, and we submit that it's somewhat alarming that the submission on behalf of the President is that there's no public interest in this matter. It's all about his procedural rights. There is a public interest of the utmost significance, and that's the release of the Public Protector's report regarding an extremely important issue for our constitutional democracy. And the direct and substantial interest which Ms. Mentor seeks is in relation to the relief that the President seeks. And so that's the first point. The second point, my Lord, is that in addition to the manner in which the President's relief is couched, in other words, seeking an interdict against, as my learned friend put it, a blanket ban, we also know that the President's approach to the Public Protector's powers is that it's not for the Public Protector to determine when he's had an adequate opportunity to respond. It's for the President to determine that. If that weren't the case, my Lord, none of us would be here. And so there is, if the President's relief were to be granted, there is the very real threat or risk that the release of this report would be delayed for a significant, if not indefinite, period of time. And so the public interest, there is a very compelling public interest in this. The second point is I just want to respond to my learned friend's allegations about Ms. Mentor's allegation that she would have been circumspect at the outset about making the public disclosures which she did if she had known that it would expose her to the risk of being questioned directly by the President. The reason that she said that is that she believed that the President would attempt to intimidate her if he were to cross-examine her in person or through his legal representative. Ms. Mentor has never objected to cooperating with the Public Protector's investigation. She did so willingly. She has never objected to being questioned by the President, provided that it's through the Public Protector. And so the suggestion that's been made that she's somehow adverse to having her version tested and that this court should draw certain inferences from it is, with respect, my Lord, entirely incorrect. And I should also add, my Lord, that Ms. Mentor did not hesitate to place her version of the relevant events on oath, whereas the President has done so. Those are my submissions.
Thank you, Advocate Lewis.
Well, just can I be permitted to make just one quick point?
2 marks.
5 marks for joking. As the court pleases. My Lord, I omitted to make the following point. The counter-application, if we are right on the fact that the counter-application is capable of standing on its own 4 legs, it must also be noted that the counter-application is not opposed. The counter-application is not opposed by the primary party that is being compelled in that counter-application is the Public Protector, who has chosen to abide the decision of the court. But neither has the President nor Mr. Van Rooyen opposed the application. In fact, at paragraph 69, or page 69 of the papers, where the DA, which they accept has an application in front of this court, says at paragraph 71 of their founding papers, for those reasons, the DA supports the counter-application brought by the EFF, COPE, and UDM. In his answering affidavit, the President does not even deal with that. So, as the court pleases, my Lord, the counter-application stands.
Thank you very much, Advocate Mpofu. Advocate Blatt, do you have anything to say, I think, on the Rule 30, or?
The Rule 30, well, I think it's a notice in terms of notice.
Yes.
And in terms of the rules of court, we have to bring a notice first to remove cause of complaint, which
Yes.
is bring an application. So it is the notice that is there before them. And it's only when they do not comply will we bring an application to do so. But and the only thing we say in relation to that
Yes.
is if there was a counter application that was self-standing, their replying affidavit would be under that case number. Because they are replying to their own counter application and not in a case number in which there is no counter application, which would mean they would have only filed a replying affidavit in this case and not in their own case. And therefore, I would have to, if needs be, to answer that, seek leave of the court to file further papers.
Yeah.
And that's why we're saying it's irregular.
It's not unduly formalistic in the sense that both case numbers are mentioned in the court order of the 14th.
The case number is only so that the two matters would be heard contemporaneously.
Yes.
It is still under the case number of 80707. Okay. It is not under the case number of 80707 and
this case number.
Okay.
Because on that day, that case wasn't before court. That case only was going to be in court on the following Tuesday.
Yeah.
They say that our notice of motion sought a blanket interdict, and we say that is incorrect.
Advocate Platt, what are you doing now?
I just wanted, the one issue that Mr. Nogatombi mentioned,
Yes.
that we sought a blanket interdict.
Yeah.
And I'm saying my notice of motion says, it merely says, interdict you prior
Yes.
to giving me relief. That's all. It doesn't say blanket, and it then says we would like 2 months
Yes.
as a reasonable time, and thereafter it could have been released. That's all we're saying.
Thank you very much. At this stage of the proceedings, I would like to park this part of the matter first and hear argument on the application brought by Minister van Rooyen yesterday. Advocate Dutoit, you should be comfortable to know that we received that application yesterday. We have read it, so you don't have to take us through it.
Yes.
Yes.
Lord, what I however cannot deal with is the intervention application, because I have no papers in answer to that. Sorry, Minister.
Yes. I hear what you're saying.
I said I cannot deal with the intervention application.
Yeah.
I have no papers
Right.
on which I can address you on the intervention application by the one that I received in court this morning. I'm not
Yeah.
talking about the DAs. I'm talking about the other. I can deal with the DA's application, but I cannot deal with this.
I'm at a loss. Please help me. You have the DA papers.
Yes.
What don't you have?
I received this document this
What
morning.
is it?
It is the intervention application by Economic Freedom Fighters, United Democratic Movement, Congress of the People. This is an application to which I have not responded. There's no answer, there are no papers in this matter. So I cannot address you on it. I can only address you on the merits of the minister's application.
I'm not quite sure where we are. You have the EFF application for intervention, which you have received. You have received it.
Yes. But I haven't answered it.
Now,
I haven't answered it because I received it this morning.
Are you not able to proceed, or are you saying you can't deal with it?
I can't deal with this without papers on behalf of the minister answering this. Part of this is irregular, I can tell you that now. So I'll probably bring an application to set aside part of it as being an irregular proceeding. But apart from that, I cannot answer this. I cannot speak to this because I have no papers on which I can address you.
Well, Advocate Dutoit, you need to make an election because today is the date that was agreed to hear the main matter. Your client launched an application yesterday and enrolled it today and asked that it either be heard on its own or together with this application. We are here. We are busy with the main application. If you say you are not ready to deal with the intervention application, you are saying to us, we should ignore you. You should go and get a separate hearing from the agent court judge who's ready and willing to hear you on that application.
Yes. The only reservation I have in that respect is that if the court, this court today, would be inclined to grant the applications of the interveners in the, call it the main application, that would affect me.
Yes.
And that's why I'm here. But I cannot deal with this. That's clear. Unless I can come back tomorrow. I can prepare a document overnight.
Could I just ask you a straightforward question?
Yes.
You have read it. I take it.
Yes.
You oppose their application for intervention.
Yes.
And it's in that regard that you want to file papers.
Exactly.
Basically, we are saying we mustn't call upon you to respond to it
Yes.
because you want to file papers.
Yes.
Yes, I had no inkling that this would be dealt with today.
Then maybe.
Yes. Lord.
Mr. Procedural, we're not quite sure. Well, I think I'm getting some clarity. You've been called upon to address us on your application.
Yes.
In your application, there's an application for intervention.
Yes.
Yes.
You seek an opportunity to file papers in response to that before you move your application.
Yes.
Obviously, we can't hear you.
No, my lord, you can't hear me.
Yes.
As you asked me, that's why I indicated that I couldn't address you fully because I can't deal with this. I need to-
Partial hearing is not going to be helpful.
No, but if I can file papers overnight, which we can...
How long will that take you?
Lord,
having regard to the fact that it's an urgent application you brought to be heard today.
Yes.
Yeah.
Yes.
My lord, our application is urgent for the reasons set out in that application. This application is brought to intervene in that application. I must deal with this application as well. I could not anticipate that when we brought our urgent application yesterday.
I agree, I accept that. My question is, and we're moving off from the basis that you would like to respond, you haven't had time to respond, and I'm asking you the question, how much time do you require to file responding papers to that? And I've added having regard to the fact that you wanted it to be heard today.
Yes.
No, we would be able to respond tomorrow. By tomorrow we can file papers. Tomorrow morning. No problem.
Well, Advocate Dutoit, when you enrolled it to be heard today, you must take the consequence of your decision to enroll it today.
Yes, Lord, I do take the consequences of that.
Yes.
But I can't take the consequences of an application to intervene today as well.
Yes.
Without being able to answer it.
Right. So we can't hear you because of that intervention application.
As the Lordship is.
Right.
Did you intend to be heard only if unopposed? I have some difficulty, so you can read it. You enroll the application for today. There's a party who says, I have an interest, I want to intervene. Now, speaking for myself, we would like to assist you to be heard. And
can I be heard tomorrow morning?
What's wrong with today?
Because I can't file papers in the court while sitting in court. It's as simple as that.
If we stood you down, you have the rest of the day.
That would be most helpful.
Will you come back this afternoon? And I'll tell you why. This is not a hypothetical question. We are dealing with a whole host of intervention applications in interrelated matter. Your matter appears to be somewhat related to the rest. And if we want to bring order in the hearing of all these applications, it would have been most convenient and accord with economy of judicial resources if we could hear you today.
I appreciate that, my Lord, but in all fairness, I do not believe that I can file papers and expect a reply by today. I can expect that by tomorrow morning at 10 o'clock, or such time as the court wishes to commence. We can deal with that quite adequately in the course of today, and we can get a reply today. The papers will then be in order.
What's your attitude to the DA application in relation to your
Our
application?
attitude to the DA application is that it stands in a different category. We do not believe that it has a direct and substantial interest, but for the sake of peace and on the basis of Section 8.3 of the Protectors Act, we do not oppose their intervention.
You don't oppose the DA's
We
intervention?
are formulating an answer to that along those lines.
Right.
We haven't been able to do it yet.
Right.
My Lords, in the light of this concession, is it not competent for this court then to direct that the DA's intervention is granted to avoid further time being spent in answering what is being conceded.
To that
To
application.
that matter, my lord, we have a further submission on the matter standing down if we will be permitted an opportunity at the court's convenience.
Well, I think what I read in what the EFF, COPE, and UDM filed is they have an issue with the agency of that application, isn't it? So before we pronounce on any intervention, I think we need to entertain arguments on whether the matter is urgent or not, isn't it?
My lord, except that the parties who would like to make submissions on urgency would only acquire the right to be heard if they can intervene.
Yes.
And for that reason, but Lord, what we are really submitting, my lord, that the court's time should not be lost by standing down on an issue of standing of political parties which has been determined as a matter of law. And for that reason, to stand it down to make papers where the law has indicated the rights of political parties to be heard on issues relating to the conduct of the president, there's no purpose in standing the matter down.
Yeah. Thank you. Advocate Mpofu.
As God pleases, my lords, I just want to point out maybe this might provide a practical solution and a quick one indeed. Firstly, in the application that we handed up in court this morning on page 3, we say this affidavit is intended to serve as both the founding affidavit in support of such relief, that is the intervening relief, as well as the answering affidavit in respect of the application brought under case number 84803, so-called Van Royen 2. So to that extent, this affidavit is exactly in the same space as the answering affidavit of the DA. That's number one. Number two, my lord, again, we're back into the world of technicalities, which are not going to help us to get to the merits of this case. On what basis, may I ask, my lord, could the concession be made that the DA, which is a political party, can intervene in the Van Royen 2 application, but the EFF and the UDM and COPE may not? These are similar parties. They come here in the earlier address. It was clear that they come on the same basis, whether it's Section 8, whether it's Section 38 of the Constitution, whether it's all the other submissions that were made in the morning. That's number two. Number three, in this application, if you cut all the frills, is merely a resuscitation of the Van Royen 1 application. And there was a full-blown application to intervene in that application. Both in the DA application and this application, we have said, we're not going to repeat what we said earlier. Go and read what you heard on the 14th of October. So there is no basis whatsoever to stand the matter down or do anything. The basis for our intervention in Van Royen 2 is exactly the same as the basis for our intervention in Van Royen 1, which was served on my learned colleagues on the 14th of October. The last point, my lord, is that on the primary question of urgency, because all this presupposes that this application is urgent. Well, that question, if my learned friend is ready, we are prepared. He can put aside our answering affidavit. We are prepared to argue the question of urgency of Van Royen 2 on his papers as they stand. As the court pleases.
Well, what's against you is that I think that's what the advocate is arguing there, that you need to be admitted first in those proceedings, isn't it? Well, as a party.
Of course, my lord. But the point I'm making is that if the hybrid nature of my affidavit is accepted, in the sense that it is both a founding affidavit for the intervention application as well as an answer to this application, that to the extent that it is an answer, the issue of urgency is raised only in that context. And with the greatest respect, my lord, unless if there's an answer to the question as to why the DA is considered to be a party and the EFF is not, then maybe the next practical suggestion would be, well, I was going to make that before that concession. I was going to make the following proposal. Let the DA then argue its case. If the DA is to be admitted as a party, then ipso facto, the other political parties should be. But then the concession was made, which makes even that practical proposal unnecessary. It doesn't make sense, with the greatest respect, Minister.
My Lord, could I make 2 points about this? The Minister brings an urgent application. Let's emphasize urgent. On a few hours' notice, they say that the application must be heard today. They know that the EFF has an interest in the application, because on the 14th of October, we were all here before Justice Fourie, and they know what interest the EFF articulated. They don't bother to cite the EFF, nor do they bother to make sure that the papers are delivered to the EFF. Then they come to court. Then they say, sorry, we are not prepared to entertain you. And not only are we not prepared to entertain you, we want the case to be stood down for the whole day. I mean, we have another 3 hours to go. The entire 3 hours must be wasted because Mr. Van Rooyen's counsel is not ready to move his own urgent application that he brought to court today. This is an abuse of process that this court should not entertain. That's the first point to be made, is that what they are now doing is that they are manipulating the processes of court, making sure that they bring an urgent application and then that urgent application is not heard on the basis that they are not ready. Mr. Mpofu is correct when he points out to your lordships that there is nothing substantial in what we say in our application for joinder. The grounds are the same as the grounds that they have had since the 14th of October 2016. If they want to oppose us, they know precisely on what basis they should oppose us. This standing down until tomorrow should simply not be entertained. They have no justification for insisting that the case must stood down. It's an urgent application, not brought by us, but brought by them. No party can come to court on an urgent basis and when they arrive in court, suddenly ask for another 3 hours to go and think what they want to do with the EFF. Particularly a party that they have known for 3 weeks that it has a direct and a substantial interest in the matter, and they've known what the facts are and what the arguments of that party is. So I would suggest that the court must refuse this attempt at postponing the application. Tomorrow, if anything, we have to deal with the merits of the case if the court decides that we are a party to the application. And today, the court must make a determination as to who is before it. Otherwise, there is a real risk that tomorrow will come and go without the application being heard. And what happens then? The application, the order that was granted by Justice Fourie, by consent, all of us acting in good faith, believing that all of the parties are interested in having the matter determined, finally agreed to. That order, now there will be an argument that it must be extended until an indeterminate date. Those kinds of technical maneuvers should simply not be entertained. So the first point to make is that the application that they are now bringing to stand down until tomorrow should simply be refused. The second point is that if they want to know what the grounds of the EFF are, they know those grounds because they've known them since the 14th of October. The last point, Mr. Mpofu has made the point. They concede that the DA has standing to join, that the DA has a direct and a substantial interest. But anybody, it's a cursory reading, who compares the EFF application versus the DA application will be struck by one thing, their similarity. On what basis then does Mr. Van Rooyen seriously say that the DA can come in but the EFF cannot come in? There is no principled basis upon which they seek to draw this artificial distinction that they are now seeking to motivate for a standing down. Yes, my senior says that it must be dismissed also for a non-joinder, but we don't want to resort to these technicalities ourselves. The point of the matter is simple. They don't have a ground to stand this thing down until tomorrow. They know precisely what the objections are. They must argue their case. If they're not ready to argue their case, then they must accept that the court must strike it off the road.
My Lord, if I may just be helpful with one point. My learned colleague has said that the so-called concession made to the DA is made on the basis that the DA asserts Section 8 of the Public Protector Act. Well, if you go to page 15 of our papers, the intervening papers, you will see that we not only rely on Section 8, but we quote it in full. Section 8, publication of the findings. We go to subsection 1, 2, 3, all up to 3. And then on the basis of that, we say we seek that's the basis on which we seek to intervene in these proceedings to give practical effect to those statutory provisions. So not only is our application, which they've had on since October, based exactly on the same point which they concede that the DA should be admitted, but it is quoted in full, and they chose not to respond to it. As the court pleases. And with the greatest respect, my lord, maybe this will be discussed at the end when we look at the question of cost generally. But we do want to take issue with the fact that Mr. Van Rooyen is abusing the processes of this court and taking opportunistic points. His so-called reason for being here, according to his affidavit, is that the EFF, UDM, and COPE and the DA may get the relief that they seek. And then he issues papers and does not serve those 4 parties. What is that? You can't say, I am here merely because these parties might get relief, which clearly is a concession of their interest in the matter. And then you don't give them papers. The reason why they received these papers at midnight is because we only heard about this application in the media, and we had to scramble all over to find the papers. And once we found the papers, it was already at about in the afternoon. And then we had to bend the midnight oil and make sure that we deal with these papers. With papers that they know that they should have served upon us. And then they come here and ask to stand it down. Let the court not be abused in this manner, my lords.
Advocate du Toit, you've had submissions. Are you changing your mind? Are you still of the same attitude that you expressed earlier? Or do you want to say anything further? Yes, you see, let me just explain. Let me just explain where we are. We invited you to come along because, as the DJP said, the application by your client raises related issues to what this application is dealing with. And your client said either it should be heard before or simultaneously with this application. Now, things have happened in this application. There are intervention applications, other interlocutory applications, and there have been responses. And in certain instances, there have been heads of arguments. So if your client elects to be heard simultaneously with this application, it cannot, by its late entry, derail the further progress of this matter if it wants to be heard simultaneously.
Lord, we were not here by invitation of the Deputy Judge President. We were here because he brought an application.
Yes.
The learned friend, Mr. Bana, is here as a result of that invitation, not I. That's the first point. The second point is I've listened with great interest as to the similarities between the economic freedom fighters and the Democratic Alliance, similarities that I had not recognized previously. But the clear difference between the two is that the Democratic Alliance was a complainant, and the economic freedom fighters and the others were not complainants to the public protector. Thirdly, I have not asked for this matter to be stood down. I've asked only that I be given an opportunity to respond to the intervention application, which is, with due respect, my procedural right to do so. I can respond to an application to intervene. It cannot simply be, I cannot simply be bundled off and said, you don't have to deal with it, we're granting it, we don't have to listen to you. That would not be correct in my respectful submission. So, that's all we're asking for, is an opportunity in our matter, that is the matter which we brought, which is the 803 matter, that we allowed to answer the intervention application. That's all we're asking.
So you do not seek to derail the further proceedings in the main matter?
My Lord, I should perhaps explain that the relief which Mr. van Rooyen asks is very limited. Everything he asks is based only on relevance to him. He doesn't ask that the report not be revealed without, in regard to anybody else. He asks that it not be disclosed, published in relation to him, where it has clearly, it contains matters to which he has not had the opportunity of responding. It is common cause on the facts that the public protector, not this one, the previous one, gave him 24 hours to respond. He could not do so, and that's why he brought the application, what is referred to here as the first application.
You don't have to take us there. We've read those papers. I asked you a direct question.
No, I'm not going to, obviously I'm not trying to derail the application here. I'm trying to respond to this. And I'm pointing out that the limited relief which Mr. van Rooyen seeks is obviously affected, could be affected by a judgment. Could be affected by a judgment of this court. And that's why we are here today, and that's why we brought it on an urgent basis. But we are entitled to answers. We believe we are. And we would ask the Orchard's leave to allow us to do so.
Just one aspect. Taking into account what you've just argued, for instance, also the difference, as you put it, between the EFF and the DA, is the question, the issue which we are debating now, not a legal question. Because if it is a legal question, why do you need time to file further papers? Why can't you argue it on the papers itself?
I can certainly argue it on our papers. I cannot deal with an application. The Lordship would perhaps should have regard to what this notice of motion asks.
But before we get to that, just a system. What is the nature of the issue? Is it a legal question or a factual question?
Our urgency is based on factual.
I'm not speaking about urgency, Mr. Sway. I'm speaking about intervention.
The intervention is both a factual and a legal issue. The factual element is that the economic freedom fighters were not complainants. The factual issue is that they must base, in relation to our relief that we ask, which is the narrow relief, they don't have a substantial and direct interest at all.
Why can't you argue that you've just put it? You said that the factual basis is what you put out to me. Why do you need time until tomorrow to put that in writing? That is what I don't understand.
Because I've got to deal with the notice of motion which asks for a declarator that all related applications have been duly consolidated. That's a factual issue. Alternatively, consolidating the related applications. Further alternative, reviving the relief sought by the first to third intervening parties in terms of a note of intervention and counter application as amended and delivered under case numbers, and then it's the two previous case numbers. Frankly, which I don't understand. But, so that is what we have to deal with in this application. I can certainly argue the lack of direct and substantial interest on a legal basis without going any further. I can't deal with this.
This is what we're prepared to do. You're seeking an indulgence from this court to respond to those papers. Right. Now, we are of the view that because of the constrained nature of the factual issues involved as well as the legal issues involved, you do not need the time you propose until tomorrow morning. We are prepared to give you until 14:15 today to file whatever response you want to file in this matter. Then we can continue with the matter. And that's based on what you've just answered to my brother Fori here and to your concession about the DA application to intervene.
Our concession, as it's termed, my Lord, let me point out, was made for the sake of peace in order to get to the root of the matter.
Yes. I have
Make peace with the DA.
Yes. We will take instructions on that, my Lord, and I'm indebted to your Lordship.
As I say, I have expressed the view of this court in accommodating your request to respond to the intervention application by the EFF, UDM, and COPE. I'm not aware if the intervening applicant mentor has filed anything in this regard. They haven't. So,
not to my knowledge.
And our preparedness extends up to 2:15 this afternoon for you to file whatever, because there's not much for you to traverse in responding to that application.
Yes.
And on that basis, we are going to adjourn until that time.
Yes. May I take a quick instruction from my attorney?
Okay.
Thank you.
We'll allow you that. Is that the one going out?
It's not the one going out.
Okay, where is he?
I think he's just standing outside. Lord, I apologize, Lord, I don't know where he is.
Mr. Titoy.
Yes.
While we are waiting, and again, in the spirit of saving time,
yes,
you have asked to be heard either together with this application or before it. We are in this application now. You're being heard before it is gone. And I want you to consider, when you are taking instruction, your attitude towards your application being consolidated with this.
The main matter.
With the main matter.
I'll take such an instruction.
Yes.
Lord, we are indebted to your lordships for the time. We cannot promise, in the circumstances where our client is in Cape Town at the moment, that we can actually produce anything by 2:15. But it will certainly give us a time to consider what His Lordship, Mr. Justice Mojapelo, proposed and to discuss that. So we will be back at 2:15.
No problem. We'll adjourn then to 2:15.
Right, that's definitely riveting scenes that we've seen from the Pretoria North High Court there, where the application to interdict the public protector's report has been heard all morning. As you can see, there's been a request for the proceedings to continue in 90 minutes' time, but it seems as if that's not going to happen. Definitely riveting legal arguments being heard throughout the morning. Definitely something very interesting. The UDM and the COPE have been arguing that Des van Rooyen and his lawyers are trying to abuse court processes by requesting an urgent application to be heard, and then on the day their lawyers say they're not ready to hear the rest of the application. Tell you what, it's been very interesting. So the application began in the High Court in Pretoria this morning, and the report was due to be released last month. However, it has definitely been held up, and we need to see exactly what's going to be delayed due to the court application. President Zuma argues that they need more time to respond. That's where we're going to leave it for now. We'll be back with more news in a few minutes' time at the top of the hour at 1 o'clock. And you've been watching SAB News.